Thank you so much for attending this webinar, Negotiating Contracts for Maximum Value and Minimum Risk. Because of the nature of what we're going to be saying today, and also because you have two attorneys, unfortunately, that are presenting this material, we do want to go ahead and before we get started, make the following disclosure, which is of course a very attorney thing to do. So I apologize in advance. The information that we are providing during this webinar does not and is not intended to constitute any type of legal advice. Instead, all of the information and the content materials that are going to be available during this webinar are for general informational purposes only. Information that we provide during this webinar may not constitute the most up-to-date legal or other information. If you would like to receive legal advice concerning any of the topics that we do cover today in this webinar, we encourage you to contact your respective attorney to obtain the advice with respect to the particular legal matter. You should not act or refrain from acting on the basis of information provided during this webinar without first seeking legal advice from your attorney. And use of this information contained in this webinar does not create any type of attorney-client relationship between you or either of the law firms that are represented here today. Furthermore, the views that we do express during this webinar are those of the presenters in their individual capacities and not of those of their respective companies. So now that we got that awful thing out of the way, I want to say again, thank you so much for joining us today. My name is Ashley Basnett. I am a managing member of Reeve Basnett PLLC. We are located in Texas. The idea for this webinar today came about after I attended several industry conferences. And at these conferences, I was seeing a lot of new business relationships and deals happening in real time, both with clients and with friends in the industry. When I would get back to the office from these conferences, clients would send me contracts to review so that they could start their new business relationship. And when I would go over them, after some time, I started to see a pattern where the contracts were not matching what the parties had negotiated at the conferences. And while it's always good to have a very good personal relationship to start out your new potential business relationship, it is equally as important to have a good contractual relationship. So at the end of the day, these business relationships, in my opinion, are a lot like marriages. Sometimes these business relationships sour over time, and it's really important to ensure that you are fully protected in the event that your business relationship goes south or there's a termination of that relationship.
And I'm just going to add on that a little bit. Before I fully jump in, my name is Nicole Parag. I am a senior attorney with Bishota Law. And often when speaking with clients and the discussions that they've had, I have every faith that you guys have been discussing the fees and the Schedule A's and some of those, limitations of liability, some of those really big hitters. And so those, we're not going to touch as much on those today. I think you guys understand those and spend a lot of time on those. But what we tend to see, and Ashley and I have had a lot of discussions on, are time and time again, there's some overlooked provisions that I don't think are as typically negotiated or talked about, at least during the initial discussions. And so these are what us attorneys call boilerplate language. Sometimes they're labeled as miscellaneous or the general terms. And so these are those boring things that you find at the end of the contract. And I think oftentimes, when you all see them and when people are reading through, you recognize them and you're like, oh, this is in every agreement, it's standard, and they get glossed over. However, these, even though they appear in most agreements or every agreement you're reading, they come in many flavors, so to say. And so we've chosen to focus this webinar on what we've kind of termed those overlooked or neglected provisions. And we are hopeful that by the end of this webinar, you will see these provisions in a different light and recognize the importance and the impact they have on those heavy negotiated provisions and every other part of your agreement. Not only from a legal perspective, but also Genevieve's going to touch on the business aspect as well.
Thanks, Nicole. So we are so excited you are here. Between myself, Ashley, and Nicole, we have a combined over 35 years in contract negotiations on behalf of hundreds of companies. So I am Genevieve Dozier, 18-year industry veteran. located in the Outer Banks of North Carolina, so not in Texas, although I was born in Texas in Lubbock and lived there for 2 years. I am Senior Business Development Specialist at Maverick Payments, and as Nicole mentioned, I will be your liaison to the business perspective today. So just for a little background, for my first 10 years in the industry, I worked for the 10th largest bank in the country, who also happened to be the 20th largest acquirer in the country with 60,000 merchants processing 18 billion in annual volume. I was head of product, among other things, which also meant vendor management. We had 3 processors and over 20 reseller referral relationships for terminals, gateways, point of sale companies, gift cards, check services, and data analytics. I then was at the 19th largest acquirer, where I was head of our FI division and managed a team that supported over 100 bank and credit union contracts with the ISO. Next, I was at First Data Fiserv, where I worked directly with over 40 retail, wholesale, FSP, and PayFac companies, writing new contracts and negotiating renewals. And then I worked at an agent company with about 1,000 merchants, but managed their negotiation going from an agent structure to a retail ISO structure directly with a processor. And at my last venture, I was the vendor in signing deals directly with agents, ISOs, and processors, similar to what I'm doing now from an ISO perspective with agents and sub-ISOs. So whether you are a company signing agreements with vendors, a vendor yourself, or negotiating directly with a processor, this discussion is definitely for you. We will not only highlight common pitfalls and risks to consider from the legal perspective, but we'll also shed light on practical implications through real life examples from, again, the business perspective. So let's jump right in.
Thank you, Genevieve. So as I mentioned before, the concept for this webinar came from attending industry conferences and working with clients after those conferences to finalize their business relationship that they negotiated themselves at those conferences. In many instances, the contracts that I am provided for review don't necessarily match the terms that were negotiated by the parties at the conference. And when this happens, I tend to get the response from clients of, don't worry about it. They said they're going to honor these terms that we discussed. It's going to be just fine. So is there something to worry about if the terms of the contract do not match the terms that are negotiated? And in most instances, the answer is yes. If there is what we call an entire agreement clause in the contract, it likely provides that the terms contained within the written agreement are the only terms that govern the relationship. So what does this typically look like? Some examples that are kind of come up now are taken from actual agreements, and they are pretty consistent when we look at what we call an entire agreement clause. And the reason why we call it that is typically in every clause that encompasses this situation, it always has the quote unquote words of entire agreement. So as you can see in the examples, it sets forth that everything that's contained in that contract, regardless of what was previously agreed to, whether orally or written, is going to come down to what is in the contract itself and not what was done outside of the agreement between the parties. So with these particular clauses, we include these clauses to ensure that if there's a conflict between the terms that are negotiated before entering into the contract, whether again, orally or in writing, the terms of the contract are going to trump the terms that were negotiated before entering into it. And in looking at some of the examples for this type of clause, they very clearly state that this contract is going to trump any negotiations or understandings that were had prior to signing the contract. So when you find yourself in situations where they tell you one thing and a different thing is in the contract, at the end of the day, if there's going to be a problem, what's in the contract is going to govern how people are going to act under the agreement.
So Ashley, I'm going to pause you there. I know you've already touched on it a little bit, but can you elaborate a little more on why this provision is so important?
Absolutely. Thank you, Nicole. So the understanding of this impact for this particular clause is really important when it comes to negotiating your agreement at conferences or other places where you are trying to start a new business relationship. So The impact, and I include this for humor and also in part as a warning, while trust is really important in a business relationship, it's not the most important thing. It is our hope that when you enter into a contract, neither party is ever going to have to refer to the contract. You can put it away and you guys are going to operate in good faith and everything's going to go really, really well. With that being said, as an attorney, it's our job to protect you in situations where the business relationship terminates or explodes, which does happen on occasion. For example, let's say that a business relationship sours and the agreement is terminated and subsequently residuals are terminated. In those situations, we look to what the terms of the agreement says. Despite the fact that they may have promised you residuals in perpetuity, if your contract states that they're allowed to terminate your residuals upon termination of the agreement, then the contract is going to trump what the negotiated terms are, and you're going to lose your residuals. So it's very important to understand what it is that you are signing, despite the fact that you may have an understanding elsewhere. It is our experience that courts will uphold these entire agreement clauses unless there are other factors present, such as allegations of fraud or negligent misrepresentation.
Yeah, and actually, I can't agree enough and can't emphasize this more from the business side. Make sure, I always tell either party, right? Make sure what they said is in the contract is not just in an email, not just pricing, but capabilities, feature functionality, service level agreements, escalations, what the process is, and then exceptions, right? If there's any exceptions they're making for you verbally, make sure that's in the agreement, because the agreement is what the vendor or the processor will point back to and not prior communication, in my experience. If you are an acquirer, ensure to focus on your protections, transparency, pricing, of course, changes, right? If they can make changes to the pricing, what are the notice timeframes and notice clauses, and make sure you're in agreement with those. So just want to add that from the business side. And then also, Ashley, when looking at these provisions, what specifically should we be paying attention to?
Yes, so because the entire agreement clause is so prevalent in these agreements in this industry, it is best practice when you are going out there and negotiating that you do operate and know that at the end of the day, those terms are going to always have to match the contract, and you and your attorney are going to have to ensure that those do match to ensure that you are going to be protected. It is very common also to see that residuals or buy rates are going to be schedules or an exhibit to the contract that you're negotiating. So you do also want to make sure that when you see an entire agreement clause, it does include that the entire agreement also includes those schedules and those exhibits, because there can be a complex issue if you have a provision that says that the terms of the agreement itself is all the agreement and it doesn't include your schedules, which show how you get paid. So you want to make sure that you include everything that you intend to be your sole agreement within that provision and referenced therein. So now we're going to go over and discuss the governing law provision. And so when we say governing law, we mean I guess it's also known as what we call a choice of law provision. And this provision is going to govern which state laws apply to the contract in the event that there is a dispute. And this typically looks like the example that's on the screen right now. It states that the laws of the state of California are going to govern the contract, as well as where any disputes would be brought. And for this specific instance, it's going to be brought in federal or state court in California. Most of the time, the choice of law provision is going to reflect the law of the state of the drafting party. However, that's not always the case. The provision is important to understand because you need to know what laws are going to govern your contract and the impact that they're going to have on respective provisions within your contract. As I'm going to address shortly, state laws can greatly differ from state to state, and the differences can have massive impacts depending on what state laws apply. When determining what the governing law is going to be for your contract, like I said, typically you have the parties either arguing over their state or the other party's state. Having a governing law in your own state can provide certain benefits, such as having access to your local counsel and little to no travel time for any court hearings. But with that being said, when we know that there's a lot of differing state laws, some parties decide that instead of picking between their respective states, they are going to select state laws that govern despite neither party being located in that state, so that they can in effect choose the best law that's the most favorable for their respective party.
So this has actually come up a lot when I've been negotiating different contracts. Either the vendor or processor is in a different state than the acquirer, right? You know, kind of what issues can arise if the parties decide to pick a state that neither party is located in.
So let's take a look at the provision that's just come up on the screen. And I've put in bold the single one word change to the contract. And this one word change has a massive impact on the contract itself. So in the example, we've changed the governing law from the state of California to the state of Nevada, and everything else has remained the same. So while generally parties are free to agree to the governing law of their choice, parties should be cautioned not to necessarily just pick them arbitrarily. Courts may refuse to enforce a governing law provision if it conflicts with either a fundamental policy of the state, or it is shown to not necessarily have a connection to the contract or the parties itself. Many jurisdictions are going to require that the chosen governing law must have some sort of reasonable or substantial relationship either to the parties or the transactions themselves. This is to ensure that we're not having total forum selection, meaning that we're not just going to go pick the most favorable state law, even though that state has absolutely nothing to do with either the parties or where any of the transactions come from. So in such circumstances where if a court were to find that the chosen governing law does not have any reasonable or substantial relationship to either the parties or the transactions themselves, the court can apply the governing law of that state, or the court can dismiss the case for lack of jurisdiction, depending on how the case is filed. And if the court applies the governing law of that state instead of the chosen governing law, certain provisions of the contract that's in dispute may be found void given that state's laws.
So when taking a look at our industry, what are some state laws that differ and how might this come into play for those that are watching?
Absolutely. No, there's a vast amount of differences that you could find, but I've highlighted two specific ones to focus on, and that's surcharging and non-solicitation. So with surcharging, the state laws concerning this matter tend to be in a constant state of change. Well, it looked like we had a lot of progress to all states eventually getting to surcharging. We've also seen regression in certain other states. So with New York, we did have some laws that were passed that would allow surcharging. However, when you look at it, their surcharging laws do not match what other surcharging laws are that allow it. Instead, with New York, it's more of a dual pricing model than it really is for surcharging. Also with California, we've just recently seen that they've enacted laws that prohibit surcharging altogether. And then you have Oklahoma, which decides to keep everybody guessing because it's did they or did they not enact it? We have, the legislator saying it's great, but does it have the final sign off? So that one's always been fun to try to navigate as well. And then when we look at the non-solicitation statutes, we have a new element of, the FTC's come out and said that there's no authorized non-competition agreements, except in very, very limited circumstances. And that left us guessing on where we're at with non-solicitation provisions. And they provided some guidance that says essentially we're going to leave the non-solicitation up to the states unless the non-solicitation obligation creates and is intended essentially to create a non-competition obligation. And with non-solicitation obligations, it is different in the vast majority of states on how they want to treat it. And in some circumstances like California and Colorado, it is not permitted at all unless you can show a very rare exception. For instance, with the California Business and Professions Code, it provides that every contract by which anyone's restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. Colorado came out after, I believe, California, and also provided their exception, which, or their provision on non-solicitation agreements, which prohibits them from being in any contract where it would prohibit the solicitation of clients and customers. So all of this to say that the laws of that are governing your agreement can have serious implications on the enforceability of some of your provisions in the agreement. And these provisions, especially with non-solicitation and former non-competition provisions, are something that you really want to make sure you understand. Is the governing law going to support the provisions that are most important to me in this contract? So with that being said, I'm going to turn it over to Nicole, and she's going to discuss a few more contract provisions you should be aware of.
Thank you, Ashley. So the next provision we're going to talk about is assignment and assumption clauses. These on a basic level dictate whether and how a party to a contract can transfer their rights and obligations under the agreement to another party. So what does this look like? When classifying this, 3 general categories came to mind. I only put 2 on the screen for a reason. The first being free assignment. The agreement explicitly states it can be freely assigned. There's no restrictions. Nothing there. This is pretty rare to see in contracts, so I didn't even include it here. The 2 you're most likely to find are what I've classified as prohibited and restricted. So prohibited sets forth that both parties or one party is strictly prohibited from transferring their rights under the agreement. And this can be a straight out prohibition, or it can kind of bleed into that third category of restricted and maybe allow it only if the other party consents. The third category, this is one that you are commonly going to see. Again, it can be either one part against one party or both parties, but there are going to be ways that the agreement can be transferred or assigned, but there's going to be limitations or restrictions on that. This, again, could come back to whether or not you are going to be required to have prior written consent from the other party. There might be conditions on that of whether or not it can be unreasonably withheld or conditioned, delayed. It might be permitted in certain circumstances, like if you are transferring to a purchaser of all or substantially all of your assets or equity, that might be allowed. So again, it's just going to be important to look at the provision, see what it's stating, because there's a lot of different ways that this particular one can be written.
So Nicole, why is this included in the contract, and why is it so important?
So it's going to come down to 3 basic things: continuity of the agreement, control, and risk management. So assignment clauses are crucial for really maintaining the integrity of the original agreement. It's going to prevent one party from unilaterally or on their own changing the other party to the contract. This really helps the parties manage risk and ensure that the contract remains between parties that are willing and able to fulfill the contractual obligations under it, rather than an unknown party or a less reliable party.
So Nicole, I heard you say that this provision applies when a party is looking to transfer their rights and obligations under the agreement. What are
Yes.
some examples you can provide related to this?
Yeah, so this typically, especially in our industry, is coming up when we're looking at a sale of the business or a sale of portfolio. Also, merger and acquisitions. For example, if a company is being acquired, the acquiring company may assume the contracts of the acquired company. But again, we're going to be looking at these provisions, see what it says, and that's going to really dictate how this plays out.
So this is really important if you are an acquirer. If you are an agent, for example, going to a retail ISO, the industry standard is no portability, no solicitation. In fact, most system limitations don't allow for portability, and solicitation is a term that is impractical based on the business model. Now, let's say you are changing structure with the same processor and you're going from a retail ISO to a FSP. So you're skipping over wholesale ISO, you're what I call a BYOB, you're bringing your own bank. So you're just using that processor purely as a processor. And yay, you win, right? The processor allows you portability, which again, I love your word rare because it is rare, but they are unable to systematically move the merchants. So I'm gonna get a little operational logistics because it's important. It's important things to consider, right? And to negotiate up front, which is what we're talking about. Like think more long-term when you're negotiating up front at the beginning, right? So unable to systematically move the merchants they're probably on a shared bin, right? So if you don't have your own bin, it's really hard to move them from a shared bin that you're sharing with, you know, thousands, hundreds of other ISOs. So you will have to manually convert the merchants from your retail portfolio to your new FSP portfolio. And there's typically a fee to do so. So make sure to check into that fee. And I'll kind of, another example would be, say you sell your retail ISO to another ISO, yay, payday for you, right? But make sure to realize that exactly what you're describing, you're reassigning, right, your portfolio to another ISO. They're assuming the liability now with that processor. Typically there's a large fee. I've seen some around at $25,000, right? So whether you're paying that or the company who's acquiring your company is paying for that, make sure to just be aware of that fee, see what it is, and know who's going to pay it, or if you're going to try to negotiate with the processor. Sometimes you can negotiate higher minimums. I've seen that in lieu of the fee. So just a little tips and tricks. Not that they'll say yes, but just a tip and trick from my experience.
No, I mean, that's great. And I love that insight. So Nicole, when we are looking at those provisions, what are some things that we should keep in mind?
Yeah, so again, it's really going to come down to the language and just understanding what limitations are there. For example, one thing I almost always go to right away, is it mutual? Who can assign and under what conditions? Is consent required? And again, under what scenarios? And then another thing to kind of keep in mind, if consent is required, do your due diligence. Look into that other party. Decide if you want to go into business with them and make sure that you're signing off and feeling confident because you are entering into business with them then, and they're going to be on that other side of that contract. So make sure you're confident in that. All right, we are going to move right along and start talking about amendment clauses. And so these type of provisions just set forth whether or not a party can amend the agreement and under what circumstances. So as you'll see, there's a lot of words on this page. I am not going to read them all to you, but when preparing for this, I had a bunch of different agreements open and kind of pulling and looking at a bunch of different ones. And this was by far the easiest provision to say, look, they can come in a million different flavors. They can say all kinds of things here. It's extremely important. So even though this provision is very easy to understand of like, yeah, we know why an amendment clause is in there. We get it. But see how different they can be. And they can truly have an impact on how your entire agreement operates. So yes, they're straightforward, but arguably one of the most important ones to pay attention to because there are so many of these variations out there that we want to make sure that we know what they say and what's in them. So what are we looking at here? And what should we be looking for? Again, another thing to really pay attention to is it unilateral? Is it only one party being allowed to amend the agreement? And if so, under what circumstances? Are they allowed to amend the entire agreement or any provision in the agreement? Or are they only being permitted to amend a certain portion of the agreement, such as one of the schedules or the fees? Often you'll see some language in there that talks about X may amend the agreement upon 30 days written notice to Y. It's a very common one we see. This is going to be very important for Y to know going into the agreement. If this is the case and this language remains in the agreement, this means at any time, I mean, the parties are negotiating X and Y, they're feeling very confident, they've changed some of the terms, they've reached some agreement, they sign an agreement. With this provision still in there, at any time, X can go by giving 30 days notice to Y and revert everything back in the agreement that had already been agreed upon. So we just need to be really careful on what's being set forth in here and just so Y is aware of what they're entering into. Also, important considerations are to consider when an amendment would go into effect. Is it immediately? Is it 30 days after notice? How are you receiving notice? Is it just written notice? Are they saying they can just post notice online on their website or through your portal that you use with them? You need to, make sure that you're staying aware of those, have notes of those so that you are constantly able to see if anything is changing or if any terms are going to be any different. Also, if you're the non-amending party, is there any sort of provision in here that, provides that if you don't accept it or aren't happy with the amendment, that you can terminate without penalty? So a bunch of different things to kind of keep in mind with these. One other big one here is when you see, especially in the amendment provision, except as otherwise provided herein, attorney's favorite clause, right? We like to add a bunch of what sounds like fluff, right? Well, when this comes into play here, this is what I see when I, in my mind, is this woo going off when it's on the amendment provision in particular. Because what does this mean? This means that if another amendment or if another provision in the agreement says that they can amend something, even if the amendment provision itself says, no, it has to be mutually agreed upon between the parties, that other provision is going to trump that. So oftentimes this is kind of snuck into different areas of the agreement. You might find it in the fee section. You might find it as a little footnote on the Schedule A, but it's really important to see, is there anywhere else in the agreement that says anything different than what the amendment provision is saying? So common language is, as set forth on Schedule A of this agreement, as may be amended from time to time. This would potentially provide a party with the ability to go in and amend Schedule A. They have permission to do that under wherever this is found, either in the fee section or on the schedule itself. So just something to keep in mind. And if it says except as otherwise provided herein, and it doesn't say otherwise in there, then that language doesn't need to be in there, right? So it should be alerting you to go find somewhere else that it might be contradictive to what was in that provision. So just something to keep in mind there. Finally, I am going to touch on survival provisions. So certain provisions are vital to protecting the interest of parties even after a contract has terminated or expired. Normally, you will see this type of clause all the way at the bottom of the contract. It typically is the last provision, if not one of the last couple provisions down there. And this one very much is overlooked. People don't really pay attention to it. They don't really care about it. One of the first things I like to do is highlight it, right? I need to know those provisions and then check on those provisions. As attorneys, we go back and forth. There are lots of revisions sometimes that go back and forth. Section numbers change, right? Sometimes sections get deleted. Sometimes we add one. So it's important to make sure that these survival clauses match what's now in the final version of the agreement. We want to make sure if it's supposed to be surviving, it's listed here. If it's not supposed to be surviving the agreement, then it doesn't need to be here anymore. A really good example of this is going back to those residuals. So if the agreement originally said that residuals were going to terminate upon termination of the agreement, it wouldn't be included here, right? But if we have then started negotiating, we've agreed that under certain circumstances, they're going to continue post-termination of the agreement, we would want to make sure that that provision is now included in this list here. So just taking the time to make sure that they are fully aligning so there's no confusion.
So Nicole, I know what provisions I look for when we have these survival provisions, and what do you generally look for when you have the survival clauses?
So it's going to depend, attorney's favorite answer. It's going to be dependent on your agreement. But typically these are the ones that we are really going to be focusing on, again, depending on the type of relationship and what's set forth in there. But confidentiality is a big one. We want to ensure that sensitive information being shared during the term of the contract is going to remain protected indefinitely, or at least for a specified period of time. And that's clear between the parties. So we want to make sure that's listed here. Also, indemnification. This protects the party against losses, liabilities that may arise during the contract term. And after it ends, we want to make sure that any actions or events that occurred during that term, they're being covered still post-termination. Warranties, representations. I already touched on the fees and residuals. Non-compete and non-solicitation are another one. And we want to ensure that the competitive landscape remains unchanged, even if the contractual relationship ends. Again, this is going to be dependent on the provision and what it entails in there. But definitely good ones to take a look at for sure.
Nicole, what are some tips to keep in mind when reviewing these provisions?
Yeah, so in these in particular, Key here is just being consistent with the other contract provisions. You want to avoid conflicts and contradictions. So we want to be clear and concise. The numbers should align. As I mentioned earlier, there's lots of revisions that go into contracts sometimes, and the numbering can change. We want to make sure the numbers are updated. But more than that, we want to make sure, as you'll see some of these examples, this is like 1.05, where some say 5. Does all of section 5 survive? And that's something to take a look at, because I think sometimes that gets overlooked. Maybe people get lazy. I don't know, but like it doesn't always make sense for all of section 5 to, or whatever section we're talking about, or section 8 to survive. So do we really mean 8.2 and 8.3, but not the rest of 8? So just making sure that we are being concise and clear, so that we don't have any confusion between the parties of which provisions are going to survive and remain to be in effect afterwards, and which ones no longer do that. So now we are going to change gears a little bit, hopefully get that wool off of everyone's eyes and get this getting a little bit more excited now. But Genevieve, we are excited to learn about some of your true and tried tips of negotiating different types of contracts from the business perspective. So I'm going to hand it over to you. And unfortunately, this Cowboys girl is really happy over here being from Dallas. I love this. And I have to say, I didn't even add this in here. But anyways, I will let you take it from here.
Yes. So talked about, okay, we're gearing up for reviewing the contract, right, from the business perspective. So I figure we'll start with timelines, but here we go. Perfect. So if your company does have formal vendor policies in place, typically this will be if you work for a larger company or a bank or a company that just has more compliance and regulation for various reasons. Find out what those policies are and pre-vet any new vendor before even starting the process. There's no need to get excited if your compliance team is just going to shut down that vendor or that product or solution for various reasons. When I worked at the bank, I had vendors, we'd see at these industry shows. I'd get excited about them. I'd wanted to work with them. They'd fill a gap, right? Or we'd actually have a value-added solution other than just processing. But maybe they were a new company, or they didn't have great financials. They couldn't provide financials, right? Then unfortunately, from a product perspective, being a top 10 bank and with all the regulatory scrutiny, I was not able to work with them. So I would just say, you're awesome, come back to me in a couple years, right? But knowing that and not wasting your time, unfortunately, and kind of knowing your lane and knowing who you can work with, right? So next, I'll call it the meeting before the meeting. So reviewing the contract ahead of time and see if there's items you already know that from whether it's your legal team or your leadership team, you're going to get pushback on. And see if, whoever the person you're working with at the other company, maybe they can go ahead and edit some of those things. And then that way, when you do provide it to your leadership and your legal team, you come in looking like a rock star, like, hey, I already negotiated this, and here's kind of the newer version they already kind of gave on some of these things, or they worked with us on this language that we change every time, right? So you can go ahead and kind of get in front of that. And always helps to reduce the back and forth slightly. So establishing a timeline on both sides. So again, kind of keeping with the idea of if you are a large company or if you're signing an agreement with a large company, this is really where establishing a timeline will be helpful, because contracts in this environment can take a lot of time. Even a simple renewal with a long established product vendor could take 2 years. Real life example, just a renewal. And so prepare on either side expectations and outline processes. So that way there's no confusion on, why is this taking so long? Hey, we went ahead and set expectations. Here's what the process is. Here's how long this will probably take. Yay, if we get it done quicker, right? We'll celebrate. So next, meet internally. So I would say, redline every point that you'd like. Sometimes from the processor perspective, if they see a really bloody bloody contract, as we like to call it, they might get offended, right? They might get mad right away. So I know some attorneys though love to do that. So I'm not going to criticize. I'm just giving experience. But I will say from you know, again, where I've been kind of the person sending the proposal, right? I want your feedback. Like, hey, if you don't like something, like, let me know. Let me see if I can do something, right? Like, don't just say, oh no, I don't like that, I'm not going to work with them, right? So that's really the point of this, is redline every point you'd like, but have an internal list, right? Meet internally with your decision makers from risk, operations, underwriting, like pull in all of your heads of your departments and say, hey, what are we willing to give on? And what are like, here's our non-negotiables. That way you already have that ready for when they come back and they respond, and then you're prepared to say, you know, yes, we're good with this, or yes, we can give on this. Again, kind of streamline that back and forth. Now, some companies may hold, and you all probably know this in your own negotiations, whether it's with the merchants directly or negotiations you all have done on that's here on the line with us. But some companies may hold back their best and final, right? Because they want that negotiation, right? I'm gonna leave with my best and final offers, whether it's pricing or different terms, right? Especially if it's a new relationship, maybe that person's newer to the industry or the specific solution. Some though may go ahead and give their best and final. Like, we know you, we see your performance, you know, we see your history. This is truly our best and final. So just know that you could get either one with that. And hopefully maybe you have an idea and a sense of that when you're going into that, you know, those negotiations, but definitely I wouldn't assume either. Just know that kind of either could be the case. Right. And then the last thing I'll notate here on this slide is, remember, setting timelines and expectations, hold each other accountable to those, right? So maybe your past kind of what you had, you know, set up in the beginning, and the agreement signing is legitimately taking too long, right? Between both parties. There's a lot of delays. Or a lot of, you know, I have to escalate this, right? Or it's a lot of meetings, again, with those bigger companies, right? This has to go to different, you know, teams to review, you know, several layers of approval. It's kind of like a ladder, a step ladder, if we will, with some companies. So real life example, as a last resort, set up a daily call between the business and legal side of both companies. I'm sure, again, this is from the business side, not the legal side. Even me from the business side, I didn't like it, but it worked. So maybe you just get on the call to do a quick check-in. Maybe it's a longer discussion where you're going through all those red lines and the responses, but I can guarantee this will get it done quicker than if you didn't have this in place. And for my real life example, especially if you make the call daily from 5 to 5:30, that person's time zone, I experienced this in real life, and it still took about a month of daily calls to get the contract signed, but I know that it would have taken longer had we not done that. So thought that was a fun real life example to give everybody if things are going too long.
And Genevieve, I really agree with you. In certain circumstances where it is taking a long time, that is really helpful to get everybody on the call, hold everybody's feet to the fire. So I am with you 100%. So what about renewals? You know, many times companies will let their contracts go on auto renewal. What has your experience been like with that approach?
Yeah, absolutely. Great question. I love kind of talking about kind of upfront negotiations, but then right naturally would be renewals. So again, I love your disclaimer at the front. My personal opinion is always give notice of non-auto renewal. Like, don't ever let it go to auto renewal, even if you plan on renewing, right? And there's a couple of different reasons for this I'll get into. You can check your contract for when this is required. So make sure you don't miss out on the notice time, because they'll say, hey, it'll go to auto renew at this date, right? You need to give us notice on this date or this many days ahead of time for it to not go into an auto renewal status. And a lot of times that could be a few months prior to. So just making sure you know what date that is, you know what you need to do to give notice, whether it's, you know, just electronic, or if you actually have to like send a you know, actual written document somewhere to give that notice. So know that process. Take this opportunity to check in and see if there's anything that you can do that is better, right? In terms of the actual terms of the agreement, a lot of what's been covered today, your pricing, or maybe there's products that you don't have access to because it wasn't negotiated originally in your contract, but you want access to those products today, and maybe there hasn't been an amendment, right? Talk with your peers, right? So I'm going to come at you if you are an ISO, if you're an acquirer. There are limitations in your agreement that says not to discuss certain things with other people. So I will state that from a legal perspective, because I've had to make people aware of that. However, we all know that, you know, as owners of acquirers and working at acquiring companies, we're all kind of frenemies. And so we like to kind of share tips and tricks. I said that at the Midwest conference and everyone laughed, because it's true, right? So, you know, you can't share exact terms, again, most of the time in your agreements, but, you know, you and your peers may be able to provide each other guidance on, you know, different ranges or ceilings or floors, or here's what I'm seeing, but here, I'm not going to tell you exactly what like my pricing is from this processor, right? But giving you examples just to make sure you're not completely out of line with the market. So again, performing a current market analysis, you know, think about it this way. If your processor agreement is a 5-year term, right, and you just let it auto renew, then when you go to your second auto renewal, 10 years have gone by and new partners are probably being boarded and may have better pricing than you because you didn't negotiate it at your renewal. Strategies can significantly change in 10 years. Loyal partners may benefit, but not the quiet ones, right? So it's like, oh, I've been with you for, okay, well, you said everything was fine. You just chose to auto renew, right? So you can kind of see from both sides how that plays out. And then, you know, what, of course, you know, as you're doing that market analysis too, you know, think about like, why are you losing deals, or, you know, why are clients leaving? Is there anything that you could do within your contract that would help you with this solution, you know, with that solution? And if you're asking, again, keeping with the example of a processor, right? If you're asking the processor to give on an item, especially pricing, they're going to want something in return, not just your loyalty. And that's probably anyone, right? Not just the processor, but contracts are a two-way street. I've heard mutual a lot today, so we'll just continue that with pricing terms. You know, what can you bring to the table? So is it net new revenue with new product sales? Do you have a new, you know, partner that's bringing certain deals, you know, some new product that you're working on releasing to the market? Net new deals you're booking elsewhere that now you're going to move. So you're moving your what we call like a top of wallet share or wallet share there. And then, you know, or maybe you want to do it, maybe you only had a 3-year term, but this time you'll sign a 5-year term, right? So a longer term. Those are just some examples of what you could offer in return. Quantify this, right? Like really put some numbers to it, be ready to provide those numbers with a timeline. Like in what time frame are you going to be able to provide this? The person you are working with will use this, right, at the processor to help justify a lower revenue in one area while then highlighting a higher return in another bucket. So, you know, most companies are looking at all the different revenue streams that you're bringing in and all the different buckets, and while they can kind of take from one, then they'll kind of put it in another. And then lastly, use an experienced payments industry attorney. So it's funny, Ashley, Nicole, and I talked about kind of, you know, these relationships are in fact relationships, right? So just like whether it's personal relationships, professional relationships, there's red flags. So, you know, sometimes it is a red flag would be, you know, kind of a DIY, right, versus using an experienced attorney. And so sure, you'll save some money, right? But you probably won't get the best terms potentially, probably in our experience, I would say. So work smarter, not harder, and it will pay off in the long term. So I'm going to see if Ashley and Nicole has anything to add, and then we will wrap up for our call today.
Thank you so much, Genevieve. That was very insightful, especially, you know, coming from our legal perspective. Sometimes it's easy to get tunnel vision on what we see on a day-to-day basis. And so I think that's extremely helpful. Nicole, do you have anything you want to add before we close this out?
No, I think in general, I just want to kind of highlight a common theme I was hearing from all of us was to make sure whatever's in the four corners of your agreement, make sure that's what it says. And it matches exactly what you've been told. And I feel like we hear that time and time again of how a relationship's supposed to work, and that's maybe not what the agreement currently states. And so making sure on a lot of different levels that they are aligning, and we're not getting any of those red flags, and we feel confident in the agreement that's been signed and ready to go.
Absolutely.
Well, thank you all so much for joining today. In the upcoming days,